A very warm good morning to everyone. Case between Paulraj versus the District Collector Kanyakumari District Nagercoil. So this judgment was pronounced by Honorable Mr. Justice C.V.KARTHIKEYAN sir. So the prayer is a writ petition filed under Article 226 of the Constitution of India, praying this court to issue a writ of certiorari. The petitioner is Mr. C. Kishore. His concern is that there has been a church allowed to be constructed in his locality. He is a resident of a village, Kanyakumari District, and we have already seen how the situation will be in Kanyakumari, as there are number of increasing churches in and around the city. The petitioner filed this complaint under Article 226 directly in the High Court. He sought a prayer relief that the church has been using loudspeakers to make the prayer here to be heard by everyone. So throughout day and night they have been using this loudspeakers, which has been irritating the petitioner, and so he has filed it. He has also questioned on what basis the church was allowed to be constructed, but the judge has quoted out stating that everyone should be in harmony and unity in diversity is what we are gonna love, and not the diversity in unity. So the judge has quoted that being a person from Hinduism, we should be tolerant enough and we should love our fellow person, and also from other religions too. We should be tolerant enough and sensible. So he has quoted out Article 15 of the Constitution and also Article 51A(e) of the Constitution, fundamental duties. So the E subclause says that to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and religional or sectional diversities, to renounce practices degradatory to the dignity of women. So the Honorable Judge also mentioned that there was one another case which was already filed by the petitioner, got disposed. So the previous case was concerning installation of CCTV camera by the person opposite to his house, who is a Christian and who has also been using loudspeakers for the prayers, and the CCTV installed by him was facing the petitioner's house. So eventually the case got disposed and the CCTV was taken away, and also it was requested that he shouldn't be using the loudspeakers for prayers. His house was actually the meeting point, and that's where people get to chant. So the collector actually never gives permission to any church for just like that to be constructed. Rather, he will analyze each and everything and factor. So it was previously applied by the respondent for the construction of the church. So herein the Honorable Judge has said that it isn't necessary for the church to use loudspeakers. Rather, they could use some other method to make the prayer to be heard in a subtle way and not disturb the peace of the people living nearby. And also it is more like a give and take policy. If the petitioner is ready to live with every other person of the other religion, then it will be of much help to the society and to himself. Because he cannot just question on what basis the permission was given for the construction of the church in that particular place, though it is a residential area. The collector actually suggested to use an old house which can be converted into a church or build something new. That is of their choice. And the Honorable Court has also and the Honorable Judge has also mentioned that if the collector can appoint some person and establish the fact that they have been misusing the freedom given to them by getting to make prayers through the speakers day and night, which will disrupt and disturb the peace of the person living in the society, if that's proven, then the speakers will be taken away and other things will also be checked once again. So the court disposed the petition with no cost consequentially, and it advised both the petitioner and also the respondent to be understandable with each other. And herein there was one case which was mentioned by the learned counsel for the petitioner, which supported, stating that the act of the respondent is not right. South India Assemblies of God versus District Collector Kanyakumari District and others. So this is a 2003 case. That was the only case which we can be seen here mentioning. So this is a simple case which tells us that we should be accepting each and everything. Recently, Supreme Court has mentioned about on what circumstance can a murder be put into, whether it is just a culpable homicide or a culpable homicide amounting to murder or not amounting to the murder. The state of Uttarakhand versus Sachendra Singh Rawat. So, state of Uttarakhand is the appellant here, and Sachendra Singh Rawat is the respondent. This happened in a wedding ceremony wherein a Magadhi function was conducted throughout, and it was celebrated by all the villagers together. So at the time of this Magadhi function, there was a quarrel between two groups, and that eventually turned into this dreadful incident of getting to be murdered. Lower court confirmed that the accused is convicted and he should be imprisoned for the lifetime. But when an appeal was made to the High Court, the High Court stated that this is just a culpable homicide and not a murder. State demanded for appeal again in Supreme Court, and it was mentioned by the Supreme Court that High Court didn't get to examine properly, and it restored the decision which was made by the lower court. It was observed and held by the court that the intention to cause death can be gathered generally from the combination of a few or several of the following among other circumstances. The Supreme Court actually mentioned a case, and it also said like on what circumstance we can assess whether a murder is just a murder directly, or whether it is a culpable homicide come murder, or whether it is just a culpable homicide not amounting to murder, or it is a culpable homicide amounting to murder. All these can be assessed based on the situation. So here are the 10 points which was discussed briefly by the Supreme Court. So I shall quote it out here. Nature of the weapon used. First, whether the weapon was carried by the accused or was picked up from the spot, whether the blow is aimed at the vital part of the body, the amount of force employed in causing injury, whether the act was in course of sudden quarrel or sudden fight or free from all fight, whether this incident occurs by chance or whether there was any premeditation, whether there was any prior enmity or whether deceased was a stranger, whether there was any grave and sudden provocation, and if so, the cause for such provocation, whether it was in the heat of passion, whether the person inflicting the injury has taken undue advantage or has acted in cruel and unusual manner, whether the accused dealt a single blow or several blows. So these are the things which was mentioned, and the judgment also referred to precedents which held that help of exception 4 can be invoked if the death is caused without premeditation in a sudden fight, without the offenders having taken undue advantage or acted in cruel or unusual manner, the fight have been with the person killed. So it is very clear from the act of the accused that first, when the fight happened in the Mehendi function, he was intervened by the villager and the problem was stopped. Second, the incident which happened wherein at the night time of 12 a.m., this accused, this person, Sachendra Singh Rawat, he went to the victim's place with a wooden piece and with which he has given many a blows. Supreme Court held that High Court failed to examine this and note this. Two incidents took place, one during the Mehendi function and the second after the Mehendi function. These two circumstances were examined by the lower court and it gave the proper and correct decision of imprisoning the accused for lifetime. But this was reduced to 10 years rigorous imprisonment by the High Court without analyzing the situation. It totally depends upon the situations and circumstances, and the intention is something which has to be noted. So let's get to meet in another video. Thank you so much.